Tenemos paso a nuestro siguiente ponente, David Wood, que viene desde Londres.
So, the situation in Great Britain, the situation in North America, is a bit different in terms of public discussion of cryonics, and I've been asked to share some of that information with you. My name's David Wood, and if some of what I say strikes you as interesting or controversial or crazy and you want to find more, you can follow me on Twitter, DW2. I will start with 3 apologies, 3 personal notes. First of all, I am not a lawyer, although I have encountered lots of lawyers in my life. You may think I've been naughty. Well, I'll explain in a moment. My training is in many fields, including philosophy, the philosophy of science, in fact. And let me just mention in passing here, I was very struck a few minutes ago by the remarks by Dr. Javier Cabo about some of the philosophy of science regarding the implications of the theories of Heisenberg and Schrödinger and Einstein for the possibilities of indefinite lifespan. I spent a lot of time looking at these scientists and their philosophies. I take a very different viewpoint from the esteemed Dr. Cabo. I think there is nothing at all in these philosophies which rules out indefinite lifespan for humans. And I also, as it happens, believe that it's quite possible that by 2040 we will have indefinite lifespans for humans. But that is a talk for another day. It's actually a talk for tomorrow afternoon. If you're not sure what you're doing tomorrow, you should sign up, I think, for one of the mini courses. Both of them are interesting. It's a hard choice. You can learn more about cryonics, or you can learn more about life extension. And if you come to the life extension one in the afternoon, I will be giving my reasons for saying there's at least a 50% chance of indefinite, healthy human lifespans by 2040. But let's move on. I also have training in the field of large-scale software systems. I was a software architect in the smartphone business, and then an executive in that industry, and that's when I encountered lawyers often. Actually, I had many good experiences with lawyers. I saw they were doing great work. So I have no bad words about lawyers on this occasion. And finally, my training's as a futurist. And as a futurist, I know well that if we're trying to think about the future of technology, we absolutely must look at the human dimension. The most important questions about the future of technology are indeed human questions. And we have to anticipate how humans as a whole will react to technologies. And they may make laws, new laws, governing and regulating technologies. And that is my subject. My second apology is I am not an Anglo-Saxon, although I'm going to talk about Anglo-Saxon law. Actually, I come from Scotland, and people in Scotland don't like always to be called English or Anglo-Saxons. But anyway, I've been living in England for nearly 40 years. I love and like many English people, and I understand quite a lot about them now. And third, I am not a cryonics insider, although I have been looking at cryonics quite hard for about a dozen years. And maybe this year or maybe next year will be the year that I sign up for cryonics. I've written about cryonics, for example, in the book that has just today been published in Spanish, thanks to my Spanish publishers. And in chapter 12 of that book, I talk about Plan B and Plan C and Plan D, including an assessment of cryonics. Quite a positive assessment of cryonics, I must say. But I'll start with my conclusion. My conclusion is, although there are positive elements of support for cryonics in the Anglo-Saxon world, there's also a lot of unclear issues. The law is by no means clear. The situation is potentially unstable. There are people who are hoping to change the law and change the regulatory framework, and it could be a turn for the worse from the point of view of supporters of cryonics. But the community, including myself and others who support cryonics, we have an opportunity to help society provide a clearer, more stable support for cryonics in the near future. And that will be the conclusion of my talk. I'm going to give 3 case studies, 3 situations of law or possible changes of law from the Anglo-Saxon world. I'll start with one area in North America where there is an anti-cryonics law in place. You may know where that is. It's in British Columbia in Canada, where it has been remarked recently by Motherboard. It's a bit strange. In British Columbia, you can buy weed, drugs, from a vending machine. You can marry someone of the same sex, not supported in the Bible, of course, but cryonically preserving yourself is practically illegal. It's practically illegal because the procedure's not outlawed, but it's been illegal since 1990 to advertise or market the sale of cryonics, lest anybody believe that you might have a chance to be brought back to life. How terrible it would be for somebody to believe that they might have a chance to be brought back to life. That is forbidden in British Columbia. You can believe that if you are a good member of a Catholic religion or Protestant religion, you might have an afterlife, but you're not allowed to have this kind of belief in the afterlife. Here's the actual law in its most recent 2004 version. You must not offer for sale cryonics if there is the expectation of the resuscitation of human remains at a future time. And I will dare to say here, I think this is a bad law. What is an expectation? If you think, well, it's 50-50, does that mean you expect it to work? If you think, well, there's maybe only 5% chance, is that good enough? Now, we can be sympathetic to what this law is trying to do. This law is trying to prevent fraudulence. And yes, there are people who might want to scam people out of their money. So why doesn't the law say that? Well, recently, Keegan McIntosh, a cryonics enthusiast from British Columbia, he signed a contract with the Lifespan Society of British Columbia to cryogenically preserve his body after death. He's basically saying to the authorities, prosecute me if you think this law is correct. And his lawyer has said, very sensibly in my view, why doesn't the government just say cryonics is permitted, but fraudulent exaggeration of the prospect of resuscitation is not permitted? Anyway, the situation is unclear. This case has not come to any court yet. The judges are not in a hurry to get involved. Keegan McIntosh is young and healthy. This may not be relevant for a long time. The second example, I'll look at a bit more detail. It's from the United Kingdom, when there was a great deal of public attention to a legal case in November last year. Lots of newspaper coverage, lots of analysis by lawyers in lawyers' journals, which I spent quite a while reading through. And I'll quote here from one of the better newspapers in Britain. We have a lot of rubbish newspapers, but this one is quite good. And they mention the Department of Health, part of the government, is reviewing regulations on cryogenics, they call it, in part because some people said it's terrible that young children, as young as 7, are being signed up for cryonics by their parents. Isn't this bad, they said? But more specifically because of something that happened as a result of a 14-year-old girl being cryonically preserved after her death. And the summary of the situation in this newspaper afterwards, is cryopreservation legal in the UK? Well, the law is a bit of a vacuum. It's unclear, according to a professor of medical law. There's no law that adequately covers this. And people are saying we should cover it. There are some opponents of cryonics, people from a different industry, the embalming industry, who are saying this should be governed and controlled. So Karen Caney of the British Institute of Embalmers expressed a lot of concern because she said the people who are doing the standby protection, these bunch of volunteers, they're a bunch of cowboys. They're running their operation out of a garage. How terrible that is. I wouldn't expect this kind of thing to be allowed. Let me tell you more about this case. So this unfortunate girl at the age of 14 had a rare, aggressive form of cancer. She didn't want to die. She did her own research on the internet, and she said, you know, there's this thing called cryonics. I would like it. And she talked to her mother, and her mother talked to her parents, and they said, you know, if you want it, we'll stand by you, daughter. And the grandparents agreed to pay for it. But, and this is why it went to court, the father was not supportive. He said, this is a waste of money. This is fraud. This is a scam. And the parents were separated. They were estranged. The father had not seen the girl. The girl did not want to see her father. And so the parents argued about whether the girl should be allowed to be cryonically preserved. And so it went to the High Court. And the girl was asked to explain to the judge from her deathbed in hospital why she wants this. I've been asked to explain why I want this unusual thing done. I'm only 14 years old. I don't want to die, but I know I am going to. I think being cryopreserved gives me a chance. She didn't say 5% or 50%. She said a chance to be cured and woken up even in 100 years' time. I don't want to be buried underground. I want to live. And I think in the future they might find a cure for my cancer and wake me up. This is my wish. And the judge was impressed. This is the judge in question. His official title is Mr. Justice Peter Jackson, but JS gave him a new name, Mr. Hero Peter Jackson, because he adjudicated in her favor. And he explained his reasons. He said, I'm not making any scientific judgment on cryonics, whether it might be right or wrong. I'm respecting the wishes of an intelligent, articulate 14-year-old who wants this thing to happen, as conveyed by her solicitor. And because her wish was granted, it gave her great comfort, and in fact, she was able to die peacefully rather than being anxious. But if we could stop the story there, it might seem to be good news. But the judge went on in his judgment, and here in italics, I'm quoting directly from his legal judgment. There's no inherent right to cryonics. In English law, you can't determine the treatment of your body after death. It's as one of the previous speakers said, you might have your wishes. There was one lord of the realm of the UK who said he wanted his body after his death to be fed to dogs because he thought that would be environmentally friendly. That was his wish. It was not carried out. It was deemed to be not in the public interest. So, although the judge says we should take account of what people say before they die, there's nothing determining that we'll follow through. And yes, the custom changes over time, but we are not making any permanent ruling here in this case. And there is a lot of legal precedent for that decision. There is a book written by a professor from Boston College Law School a few years ago. She looks at lots of legal issues about whether what the people say before they die can be acted in the future. It's a good book and has quite a few sections about cryonics in it. The judge said, the reason I am ruling in favor of the girl in this case is because the hospital has said they support it. The hospital says, we think the girl will have a more peaceful death. She won't be agitated. She won't be distressed if this is allowed. So we are thinking of what's best for the girl in her last few weeks of life. But the hospital trust does not endorse cryonics. In fact, as we heard earlier from David Gifford from Cambridge, most professionals feel deep unease about cryonics, most medical professionals, and in fact what happened in this particular case made them more uneasy. The judge said this is not established precedent. If another hospital had a similar decision to make, they would be entitled to reach an opposite conclusion to say, no, we won't have the cryonics volunteers in our hospital, and if it was brought to court, the judge would be entitled to reach a different conclusion. Because there were quite disturbing things happened at the hospital on the day of the girl's death. Particularly, the mother was preoccupied by running around, liaising with the volunteers, didn't give much of her time to hold the girl's hand and comfort her. The voluntary organization seemed to be under-equipped and disorganized. After all, they are voluntary. After all, they're working on a small budget. After all, some of their equipment had broken down and they were using alternative equipment. And although the body was preserved well, she died peacefully, the process was handled in a way that caused real concern to the medical and mortuary staff, and the judge therefore said, you know, this case suggests the need for proper regulation of cryonics preservation in this country. We should not just leave it to individuals and volunteers to do what they want. But you know, and I'm making a general point now about regulations in any field, if regulations are imposed from the outside, it's often bad news for the people being regulated. In Great Britain, for a number of decades, the motor industry was held back by the politicians who said, we shouldn't let these dangerous cars go more than 4 miles an hour. What's that, 6 kilometers an hour? They may frighten the horses. You have to walk in front with a red flag. And that did hold up the British motor car industry. Maybe that's one reason why today it's far behind the German and French. I don't know. Why was this rule put in place? In part because the members of Parliament had invested heavily in railways. They wanted to get lots of money from their railways investments, and they were afraid of a competing industry. So there is a threat over the cryonics industry if we let the regulations be shaped by outsiders. They may just say, a bad thing happened, we've got to stop this bad thing ever happening again, without thinking about the good that the industry is doing. And regulations can be hijacked for people for religious reasons or people who belong to an alternative industry that might lose a lot of business, perhaps if cryonics becomes more popular. And there's one last case I want to refer to, a similar case in 2004. It's a different kind of case. It's when people try to change the law in Arizona, where Alcor are now based. And they tried to put Alcor under the control of something called the State Funeral Board, which is run by a group of embalmers. And this incident came about because of a bit of a scandal in the same way. The scandal involved this gentleman playing this sport. Now, I don't know much about this sport. I'm told it's baseball. I'm told it's quite popular in North America. And this gentleman, Ted Williams, is said by many to be the best striker of the baseball ever. When he died, there was a lot of controversy. Some of his children said he wanted to be cryopreserved. Others of his children said, no, he didn't. We want his inheritance, please. And a newspaper called the Sports Illustrated went in search of a scandal and wrote it up in a very scandalous way. And to tell you about Sports Illustrated, in case you're not familiar with it, when I did my research for this, I wanted a picture of Sports Illustrated. I typed into Google search, show me images from Sports Illustrated, and in a moment, my laptop screen was full of pictures of almost naked women. And I thought, oh my goodness, if my wife walks in here, I'm really in trouble now. That's the kind of magazine it is. And they said what happened to Ted Williams, and they had lots of scandal. You know, his head was cut off. His head had holes drilled into it. His head was almost dropped on the ground. And it made people say, is this really what's happening with cryonics? We've got to control it. We shouldn't let these cowboys do what they want. But Alcor fought back very intelligently with great arguments. It's on their website. You can read the history. Brian Wolk, an organ preservation researcher, wrote a long case saying this was actually, most of it was standard procedure. Of course, sometimes in cryonics, the head is decapitated because that's how cryonics often works. And he said it would be completely wrong to give over the control of cryonics to the embalmers, to the people who cosmetically dress up dead people to make them look good. It would be like giving control of brain surgery or throat surgery to the embalmers. It's totally inappropriate. So that case was fought off, and the people who tried to change the law were not successful on that occasion. The cryonics industry won that battle, but is the war over? And this is my last slide, my final summary. I think there are more threats on the horizon if there are more examples of cryonics, and if there are cases which the public perceives as being frightening or bad practice, then we might be regulated. So it is in our interest in the cryonic community to take the lead here, rather than having regulations being imposed from outside. We must decide ourselves what counts as good standards. Not heavy standards, not exhaustive standards, but the few things that really matter. And if there are new cryonics organizations that arise, and there are new ones coming, as we heard from Jose Cordero, these should be subject to agreement with these, otherwise they should not be recommended by the cryonics community. And I was very pleased to hear at the end of yesterday's session the announcement about a cryonics international voluntary organization, of which already contains 17 non-profit organizations from the cryonics world. So let's get these standards agreed. Let's look forward to hospitals saying, yeah, this makes sense. This is what you do, and we will cooperate with you. And maybe some of the medical professionals will even do training in what's necessary for cryoperfusion, rather than having volunteers needing to be shipped in from outside. So that's what I'd like to see. Ideally, we'd also like to get agreement on the point that the speaker from Italy mentioned, that there should be a way to say, no autopsy for me, please. In what already happens in some states in America for people who can claim that their religion is against their bodies being autopsied. So we can say that it's our profound belief, our metaphysical belief, if you like, that it would be a tragedy if our body was dissected for autopsy. So let's get that law in place too in due course. And ideally, an extra bonus is that we would get support for elective cryoeuthanasia. That's in cases when our brains are deteriorating faster than our bodies, and which we worry that if we wait, then eventually we will be preserved with our brain already deeply deteriorated. There was a case exactly like this that was brought to the American law in 1993 by Thomas Donaldson. Thomas Donaldson was an American mathematician who discovered cryonics in 1976. He wrote a lot about it. He was an influential thinker. And then, 1988, at the young age of 44, he discovered he had an aggressive form of brain cancer. He did not want that brain cancer to wreck his brain before he died. So he asked the courts in America for approval if he decided at some later stage to commit suicide, and then he would be cryopreserved. And the American law voted decisively against him, so there is no legal support for that yet. But I think there are cases when that might apply. In fact, if I look ahead at my own future, there's maybe a 25% chance I might want that to happen to myself, and maybe others about the same age as me, 58, might be in the same situation. So that is what we should get. Step by step, let's put our house in order, let's get agreement on standards, and then we can help society as a whole to have a good and positive support for what we do. Thank you very much.